Hello everyone, and welcome back to the channel. Growing up in South Africa, you learn a few things very quickly. 1. The weather can give you all 4 seasons in a single day. 2. A braai is not just a barbecue. It's a sacred cultural event. And 3. The idea of justice is supposed to be the bedrock of our democracy. We see Lady Justice, right? She's got the scales, the sword, and the blindfold symbolizing impartiality. But what happens when the people holding those scales start peeking from under the blindfold? What happens when they put a thumb on one side, weighing it down with bribes and personal favors? It's a scary thought, because when justice is for sale, the very foundation of society begins to crumble. Today, we're doing something a little different, something that might make some people uncomfortable, but it's a conversation we need to have. Today, we're counting down the top 10 most corrupt magistrates in South Africa. Now, I know what you're thinking, a top 10 list. Is this a Letterman special? But this isn't about entertainment. This is about shining a light into the darkest corners of our judicial system. The impact of corruption in the courts isn't just about criminals getting away with things. It's about the ordinary person losing faith, the person who believes the system is rigged against them from the start. It's about the erosion of trust, which is far more dangerous than any one criminal act. So buckle up. We're going to be looking at specific cases, allegations, and the patterns of behavior that have landed these individuals in the spotlight for all the wrong reasons. This isn't just a list. It's a series of stories that paint a larger, more troubling picture of the challenges facing South Africa's judiciary. It's a deep dive into the moments where the gavel fell not for justice but for personal gain. We need to understand the problem to even begin to think about the solutions. So let's get into it. Let's unmask the people who were supposed to be our guardians of the law. Kicking off our list at number 10 is a name that might sound common, but the allegations against him are anything but. Magistrate John Smith. Now, Smith presided over a courtroom in a bustling metropolitan area, a place where the dockets are perpetually overflowing. You'd think being overworked would be his biggest problem, but it seems he found a side hustle. The story that brought him into the public eye involved a series of seemingly inexplicable bail decisions. We're talking about repeat offenders, individuals facing serious charges like armed robbery and organized crime, suddenly being granted bail on suspiciously lenient terms. It was like watching a revolving door, but for very dangerous people. Reporters and watchdog groups started noticing a pattern. It wasn't just 1 or 2 questionable calls. It was a consistent trend. The same defense attorneys, known for representing some rather unsavory clients, seemed to have incredible luck in Magistrate Smith's courtroom. It was almost magical. They'd walk in with a client who, by all accounts, should be considered a flight risk, and walk out with a bail amount that was less than the price of a second-hand car. The prosecution would be left scratching their heads, wondering if they had missed a crucial piece of exculpatory evidence, or if the magistrate was reading a completely different set of laws. The plot thickened when a whistleblower, a clerk from within the court system, came forward. This individual alleged that consultation fees were being paid to a middleman, a fixer who had a direct line to Magistrate Smith. The system was allegedly simple. You want a favorable bail hearing? You pay the fee. The money would allegedly be exchanged in cash, in brown envelopes, in parking lots. All the classic tropes you see in the movies. Except this was real life, with real consequences for the community. The more dangerous the client, the higher the price for their temporary freedom. The investigation that followed was a painstaking process of connecting the dots. Financial records were scrutinized, and while direct transfers were, of course, non-existent, investigators started looking at Smith's lifestyle. There were sudden, extravagant purchases, holidays that didn't quite match his official salary, and a lifestyle that seemed to defy the budget of a civil servant. It was a classic case of someone living well beyond their means, raising red flags that were impossible to ignore. The allegations pointed to a man who had allegedly turned his sacred duty into a transactional business. While the formal proceedings against Smith are complex and ongoing, his case serves as a stark entry point into our countdown. It highlights one of the most common and insidious forms of judicial corruption, manipulating the bail process. This isn't just about letting one person out. It's about sending a message to the criminal underworld that justice has a price tag. It undermines the very first step of the legal process, creating a system where freedom isn't determined by the rule of law, but by the size of your wallet. A truly chilling thought. Coming in at number 9, we have the case of Magistrate Thabo Mokoena. His story takes us to a smaller, more rural jurisdiction, a place where everyone knows everyone, and the magistrate is often one of the most respected figures in the community. But respect, it seems, can be a cloak for corruption. Mokwena's alleged specialty wasn't bail. It was the art of the disappearing docket. Cases that were set to go to trial, cases with solid evidence and ready witnesses, would suddenly vanish from the court roll. It was administrative magic, or so it seemed. The complaints started as whispers among local police officers and prosecutors. They would spend months building a strong case against a local crime boss involved in stock theft, a huge problem in rural economies, only to find the case postponed indefinitely. Then, it would be struck from the roll due to a missing docket or a procedural error. At first, it was chalked up to the inefficiencies that can plague any bureaucratic system. But the pattern became too consistent to be a coincidence. The same powerful local figures always seemed to benefit from these convenient administrative hiccups. The corruption allegedly ran deep. It wasn't just about making dockets disappear. It was about actively sabotaging the state's case from the bench. Witnesses would be intimidated, not by thugs in the street, but by the magistrate himself through dismissive treatment and procedural roadblocks. Key pieces of evidence would be ruled inadmissible on flimsy technicalities. Mokoena allegedly became an expert at exploiting every loophole and ambiguity in the law, not to ensure a fair trial, but to guarantee a specific, predetermined outcome for those who had paid for his favor. The turning point came when a frustrated young prosecutor decided to set up a sting operation with the help of an undercover officer. Posing as a representative for a businessman facing fraud charges, the officer approached a known associate of Mokoena. The conversation, which was secretly recorded, was chillingly straightforward. A specific amount of money was quoted to make the fraud case go away. The money was paid, and just as promised, at the next court date, Magistrate Mokoena dismissed the case, citing a lack of evidence that the prosecution claimed was ironclad. This sting operation provided the smoking gun that investigators needed. It moved the allegations from the realm of strong suspicion to concrete evidence. The subsequent investigation uncovered a network of corruption, with Mokoena allegedly at its center, manipulating outcomes for everything from drunk driving charges to serious commercial crimes. His case is a terrifying example of how a single corrupt official in a small town can hold an entire community's sense of justice hostage, creating a local fiefdom where the law is not what is written in the books, but what is whispered in backroom deals. At number 8, we examine the case of Magistrate Zanele Khumalo, and her story is a lesson in how nepotism and corruption can become inextricably linked. Khumalo presided in a commercial court dealing with complex civil disputes, contract law, and liquidations. These are not the gritty street crime cases. This is where fortunes are made and lost with the stroke of a pen. The integrity of the magistrate in these cases is paramount, because the economic consequences of a biased judgment can be staggering. Her corruption wasn't about brown envelopes in parking lots. It was far more sophisticated. The red flags began to appear when legal observers noticed a peculiar pattern in her rulings. A specific law firm, one where her own cousin was a senior partner, seemed to have an almost supernatural success rate in her courtroom. It didn't matter how weak their case appeared on paper, they would consistently win favorable judgments. Opposing counsel would present mountains of evidence and compelling arguments, only to be systematically dismantled by Magistrate Khumalo on procedural grounds that seemed to be invented on the spot. It was a masterclass in judicial gymnastics, all seemingly in service of one particular firm. The allegations were that Khumalo was not just ruling in favor of her cousin's firm out of family loyalty. The suspicion was that she was receiving a kickback, a share of the massive legal fees and settlement awards that the firm was winning thanks to her judgments. This is incredibly difficult to prove. The money wasn't flowing directly to her, but investigators started looking at the extended family's finances. Suddenly, there were new property developments, luxury vehicles, and overseas trips being enjoyed by family members who had no discernible source of income to support such a lavish lifestyle. One specific case brought the issue to a head. A major liquidation dispute involving hundreds of millions of rand and affecting the jobs of hundreds of employees landed in her court. The company being represented by her cousin's firm was, by most accounts, clearly in the wrong. Yet Khumalo's judgment was a complete victory for them, a decision that baffled independent legal analysts. The losing party, a multinational corporation, refused to let it go. They hired forensic investigators who dug into every aspect of the case and the magistrate's history. Their findings, presented in a formal complaint to the Judicial Service Commission, painted a damning picture of bias. They detailed over a dozen cases where Khumalo had presided over matters involving her cousin's firm without recusing herself, a clear conflict of interest. They presented statistical analysis showing the firm's win rate in her court was an anomaly. Magistrate Khumalo's case is a powerful reminder that corruption isn't always about cash in hand. It can be about abusing power to enrich one's family and associates, creating an uneven playing field where justice depends not on the merits of your case, but on who you know. Our number 7 spot goes to Magistrate Sipho Dlamini, whose alleged brand of corruption was less about stealth and more about brute force from the bench. His domain was the regional courts, where more serious crimes are tried. Dlamini cultivated a reputation as a no-nonsense, tough-on-crime magistrate. But behind this veneer of strictness, a darker pattern of behavior was emerging. His corruption wasn't just about taking bribes to secure acquittals. It was about using his power to intimidate and extort money from the very people he was supposed to be judging. The modus operandi was allegedly cruel in its simplicity. When a defendant, particularly one who seemed to have some financial means, appeared before him, Dlamini would adopt an overtly hostile and aggressive posture from the outset. He would dismiss their legal arguments out of hand, make threatening comments about the maximum possible sentence, and create an atmosphere of utter hopelessness. The message was clear: you are going to jail for a very, very long time. This wasn't judicial sternness. This was psychological warfare conducted from the bench. After this initial shock and awe treatment, a court orderly or a clerk, allegedly acting as Dlamini's bagman, would approach the defendant's family or their lawyer during a recess. The message would be delivered discreetly. The magistrate is in a very bad mood, but perhaps his mind could be changed. A contribution could ensure that he looks at the case more favorably, perhaps considering a lesser charge or a more lenient sentence. The families, terrified by the magistrate's public display of aggression, would often feel they had no choice but to pay up. This extortion racket was incredibly effective because it preyed on people's fear of the justice system. Many of the victims were likely guilty of the crimes they were charged with, but they were being forced to pay a bribe not for an acquittal, but simply to receive a fair sentence instead of a vindictive one. It was a perversion of the entire legal process. The amount of the bribe would allegedly be tailored to what the bagman thought the family could afford, turning the courtroom into a marketplace of fear. The scheme began to unravel when one brave lawyer, whose client was being subjected to this treatment, decided he'd had enough. He collaborated with the police's anti-corruption unit. During the next encounter with the intermediary, the lawyer was wearing a wire. The entire transaction, from the demand for money to the promise of a lighter sentence straight from the magistrate, was captured on tape. The subsequent raid on the magistrate's chambers and the intermediary's home reportedly uncovered cash and records of other similar transactions, revealing a systematic and predatory abuse of power. Dlamini's case shows us the terrifying face of corruption, where a judicial officer doesn't just accept bribes, but actively creates the fear that generates them. Halfway through our list, at number 6, we have the intriguing case of Magistrate Lerato Maseko. On the surface, she was a respected magistrate in the Land Claims Court, a uniquely South African institution tasked with addressing the injustices of apartheid-era land dispossessions. This is a court where emotions run high, and the decisions have profound historical and economic significance. Maseko's alleged corruption wasn't a simple cash-for-judgment scheme. It was a complex web of insider trading and property manipulation, using her judicial knowledge for personal enrichment. Maseko presided over cases where large tracts of land, often prime real estate on the urban fringe, were being claimed by communities who were forcibly removed decades ago. These cases are notoriously complex, involving historical records, competing claims, and government compensation. The key thing is that the outcome of these cases could dramatically affect property values. A successful land claim could mean a huge government payout to the claimants, or the transfer of incredibly valuable land. Maseko was in the perfect position to know which way the wind was blowing long before the public did. The allegation is that Maseko was using this inside information to enrich herself and a syndicate of property developers. Here's how it allegedly worked. Maseko would get a sense of which land claims were likely to be successful and result in a financial settlement rather than a land transfer. Before her judgment was made public, she would tip off her associates. These developers would then approach the claimant communities, who were often impoverished and desperate, and offer to buy their claim rights for a fraction of their future value. The community, unaware that a massive settlement was imminent, would often agree to the quick cash. Once the rights were secured, Maseko would issue her judgment, awarding a multi-million rand settlement to the claimants. But the claimants were no longer the claimants. The property developers now held the rights. They would then collect the massive government payout, having acquired the claim for pennies on the dollar. It was a sophisticated and deeply cynical scheme that exploited the very people the Land Claims Court was designed to help. It was turning a tool of restorative justice into a mechanism for predatory capitalism. The pattern was eventually noticed by an investigative journalism unit that was looking into suspicious land deals around major cities. They saw the same group of developers acquiring claim rights just before massive settlements were awarded, and they traced the connection back to the one common denominator. All the cases were presided over by Magistrate Maseko. Financial investigations allegedly revealed a flow of funds from the developers to shell corporations linked to Maseko's family members. Her case is a sobering example of how corruption can mutate to fit its environment, twisting a process meant for healing and justice into a vehicle for calculated greed. Stepping into the number 7 spot on our countdown is Magistrate Themba and Ndlovu, whose story highlights the insidious nature of corporate capture of the judiciary. Ndlovu didn't preside over gritty criminal cases or emotional land claims. His courtroom was the specialized commercial crimes court, the battleground for high-stakes corporate warfare, fraud, and industrial espionage. Here, the players are powerful corporations with deep pockets, and the alleged corruption was not about cash in an envelope, but about a future seat on the board. The allegations against Ndlovu center on his relationship with one specific multinational mining corporation that was frequently embroiled in litigation. This company faced numerous legal challenges, from environmental damage lawsuits to accusations of fraudulent accounting practices. Yet, whenever their cases landed in Magistrate Ndlovu's court, they seemed to enjoy a remarkable run of good fortune. Complex cases against them would be dismissed on technicalities, and private prosecutions brought by activists would be blocked at every turn. He was, for all intents and purposes, the company's judicial guardian angel. The suspicion was that Ndlovu wasn't receiving direct payments. The arrangement was far more patient and subtle. The unspoken promise was allegedly a lucrative post-judicial career. Once he retired from the bench, a cushy, high-paying position on the mining company's board of directors, or a senior role as their in-house legal counsel, would be waiting for him. It's a form of delayed gratification corruption. You do us favors now, using the power and protection of your judicial office, and we will reward you handsomely later, once you're out of the public eye. This created a massive conflict of interest that was hidden in plain sight. Every ruling Ndlovu made in favor of the company could be seen as an investment in his own future. He wasn't just a magistrate, he was allegedly auditioning for his next job. This made it incredibly difficult for opposing parties to get a fair hearing. They weren't just arguing against the company's lawyers, they were arguing against the magistrate's own vested future interests. The scales of justice weren't just tipped, they were bolted to the floor in the company's favor. The scandal finally broke when a series of leaked emails from within the mining company surfaced. The emails, published by a consortium of investigative journalists, allegedly detailed conversations between company executives about their man on the bench. They discussed legal strategies that relied on Ndlovu's predictable and favorable rulings. While there was no explicit mention of a job offer, the language used strongly implied a cozy and inappropriate relationship. The revelations forced Ndlovu to recuse himself from all cases involving the company and triggered a formal investigation. His case is a chilling illustration of how the lure of future wealth can corrupt the present, turning a public servant into a corporate asset. At number 8, we delve into the case of Magistrate Nomsa Mthembu, whose alleged corruption operated in the shadows of the court's evidence room. Mthembu worked in a busy district court that handled a high volume of cases, including drug offenses, illegal firearms possession, and assault. In many of these cases, the physical evidence is the cornerstone of the prosecution's case. The drugs seized, the weapon used, the DNA sample, These things tell a story that is hard to refute. Mthembu's alleged scheme was to make sure that evidence never got its day in court. The problem first came to light through an audit of the court's evidence locker, a secure room where exhibits for upcoming trials are stored. The audit revealed an alarming number of key exhibits had either gone missing or been tampered with. Bags of confiscated drugs were found to have been replaced with talcum powder. Unlicensed firearms, crucial to a prosecution, had vanished entirely. At first, this was blamed on sloppy procedure or a corrupt clerk, but the pattern was too specific. The missing evidence always corresponded to cases on Magistrate Mthembu's role. The allegation was that Mthembu was working with a network that included court clerks and possibly police officers. The system was allegedly a well-oiled machine. A defense attorney representing a client with a seemingly unwinnable case would approach the network. A fee would be paid. Mthembu would then ensure the case was delayed and postponed multiple times, creating a window of opportunity. During this time, the crucial piece of evidence would be lost or compromised while in storage. When the case finally came to trial, the prosecutor would be standing empty-handed. They would have to inform the court that their primary exhibit, the very thing the case hinged on, was missing. Without the evidence, the state's case would collapse. Magistrate Mthembu would then, with a feigned sigh of regret, have no choice but to dismiss the charges and acquit the defendant. It was a perfect crime, committed within the very walls of the justice system. The investigation into this syndicate was a complex counterintelligence operation. Investigators had to plant marked evidence and track its movement through the system. They used surveillance to identify the clerks and officials who had access to the evidence room and documented their interactions with certain lawyers and with Magistrate Mthembu herself. The breakthrough came when they caught a clerk on camera swapping out an evidence bag. His subsequent confession implicated the entire network, with Magistrate Mthembu allegedly being the ultimate beneficiary and mastermind, the one who controlled the court roll to make the scheme possible. Her case reveals a deep-seated, systemic corruption that attacks the very physical proof of a crime. Our number 9 entry, Magistrate Bongani Sithole, brings us to a form of corruption that is particularly insidious because it manipulates not just evidence, but people. Sithole presided over serious and violent crime cases, where eyewitness testimony is often the difference between a conviction and an acquittal. His alleged corruption involved the manufacturing and discrediting of witnesses. He didn't just bend the law, he allegedly created a false reality within his courtroom to suit the needs of those willing to pay. The scheme allegedly had two sides. On one side, if a defendant was guilty and the state had a strong eyewitness, Sithole would systematically discredit that witness. During testimony, he would interrupt them, question their motives, and allow the defense to engage in aggressive and often irrelevant lines of questioning. He would create a record that made the witness appear unreliable, confused, or dishonest. When it came time for judgment, he would dismiss their crucial testimony as unconvincing, thereby gutting the prosecution's case and leading to an acquittal. The other side of the coin was even more sinister. In cases where the defendant had no alibi, Sithole's network would allegedly procure ghost witnesses. These were people paid to commit perjury, to appear in court and provide a false alibi, or a fabricated version of events that exonerated the paying defendant. Sithole, in turn, would treat these paid liars with the utmost respect and credibility. He would praise their clear and convincing testimony in his judgment, giving it the judicial stamp of approval and creating a false basis for an acquittal. This created a surreal environment where truth and fiction were inverted. Honest citizens who had witnessed a crime were treated like criminals, while paid perjurers were treated like pillars of the community. The practice came under scrutiny when a group of prosecutors from the same jurisdiction started comparing notes. They realized that in cases before Magistrate Sithole, their most reliable witnesses would inexplicably crumble, and defendants with no defense would suddenly produce a surprise, ironclad alibi witness at the last minute. The pattern was too frequent to be coincidental. The downfall began when one of these ghost witnesses, who had been paid to provide a false alibi in a murder trial, had a crisis of conscience. Racked with guilt, he approached the authorities and confessed everything. He detailed how he was recruited, who paid him, and what he was told to say. He also provided details of his handler, who was the link to Magistrate Sithole's inner circle. This confession blew the lid off the entire operation, leading to a massive investigation into dozens of suspicious acquittals that had come out of Sithole's court. His case is a chilling reminder that the deepest corruption attacks the very concept of truth itself. As we near the top of our list at number 2, we find Magistrate Palesa Molefe. Her case is perhaps one of the most dangerous, as it involves the toxic intersection of judicial power and political influence. Molefe presided in a high-profile court in the country's capital, a court that frequently handled politically sensitive cases involving high-ranking government officials and politicians accused of corruption. Her alleged role was not just to be a magistrate, but to be a gatekeeper, a protector of the politically connected. The allegations against Molefe were not about small-time bribes for lesser offenses. They were about derailing massive corruption cases that threatened to expose rot at the highest levels of power. When a prominent politician was charged with looting state funds, the case would, with surprising frequency, be assigned to her court. Once there, the case would enter a state of legal limbo. Molefe became a master of the Stalingrad defense, allowing endless, frivolous pretrial motions and procedural delays that would stretch for years. The goal was not necessarily an acquittal, but judicial exhaustion. By allowing the defense to argue over every minute detail for years on end, witnesses' memories would fade, public interest would wane, and the prosecution's resources would be drained. Key documents would go missing during these long delays, and prosecutors would be reassigned. The case would eventually die a slow, quiet death, not with a bang, but with a whimper, struck from the roll due to the unreasonable passage of time, a delay that Molefe herself had actively facilitated from the bench. The quid pro quo was allegedly not direct cash payments, but power and position. By protecting powerful political figures, Molefe was allegedly assured of her own career advancement. The promise of promotion to a higher court, a seat on the high court bench, was the carrot dangled in front of her. She was not just judging the law. She was playing a political game, using her gavel to shield her patrons and secure her own ascent up the judicial ladder. This made her incredibly powerful and incredibly dangerous to the rule of law. The cracks in her armor appeared when a judicial watchdog organization conducted a detailed analysis of her record. They published a report showing a statistically impossible pattern of delays and dismissals in cases involving politically exposed individuals compared to her handling of ordinary cases. The report, filled with data and case studies, created a media firestorm and immense public pressure. It led to calls for her to recuse herself from all political cases and prompted a formal inquiry by the Judicial Service Commission, which began to scrutinize her judgments and her relationships with key political figures. Molefe's case is a stark warning of what happens when the judiciary ceases to be a check on power and instead becomes its servant. And here we are at the number 1 spot. This is the case that encapsulates the worst of all worlds, Magistrate Andile Mabuza. His story is not just one of corruption, it's the story of a magistrate who allegedly ran his courtroom like a criminal enterprise, a syndicate boss in a robe. Mabuza presided over the organized crime court, the very place designed to dismantle the syndicates that plague society. The shocking allegation is that he became one of them, using his position to protect gangsters and drug lords in exchange for a cut of their profits. Mabuza's alleged operation was breathtaking in its scope. It combined all the elements we've seen before. He manipulated bail for high-ranking gangsters like John Smith. He made dockets and evidence disappear, like Thabo Mokoena and Nomsa Mthembu. He intimidated witnesses and used ghost witnesses like Bongani Sithole. He didn't just specialize in one form of corruption, he was a one-stop shop for defeating justice. He allegedly had a network of corrupt police officers, prosecutors, and clerks all on his payroll, paid for with money from the very criminals they were supposed to be putting away. The syndicate he allegedly protected was involved in international drug trafficking, cash-in-transit heists, and contract killings. These were not petty criminals, they were violent and powerful figures. In Mabuza's court, they were untouchable. Wiretap evidence would be ruled inadmissible. Key witnesses would recant their testimony after being intimidated, a process Mabuza would facilitate by leaking their identities to the syndicate. He allegedly ran a full-service protection racket from the bench, ensuring the criminal enterprise could operate with near-total impunity. The sheer audacity of the operation was its strength for a long time. It was so corrupt, so total, that it was hard for anyone to believe. Honest cops and prosecutors who tried to stand up to it found their cases sabotaged and their careers threatened. Mabuza was the kingpin, and his courtroom was his castle. The investigation that finally brought him down was one of the most complex and dangerous anti-corruption operations in the country's history. It had to be run by a small, hand-picked task force, completely firewalled from the rest of the justice system, because the rot was just that deep. The task force used deep undercover operatives who managed to infiltrate the crime syndicate itself. Over many months, they gathered evidence not just on the gangsters, but on their judicial insurance policy, Magistrate Mabuza. They recorded conversations where syndicate leaders boasted about owning the magistrate and discussed payments made to him. The final takedown was a coordinated series of raids that arrested not only the crime bosses, but Mabuza himself, sometimes in the middle of court proceedings. The case of Andile Mabuza stands at number 1 because it represents the ultimate betrayal. When a guardian of the law allegedly becomes the linchpin of the criminal underworld, the justice system doesn't just bend, it breaks completely. So there you have it. 10 stories, 10 examples of how the sacred trust placed in our judicial officers can be shattered. From simple greed to complex conspiracies, these cases paint a disturbing picture. It's easy to feel disheartened, to feel like the system is broken beyond repair. But despair is a luxury we can't afford. The fact that these stories are public, that these magistrates have been named and are facing investigations, is in itself a sign that the fight is not over. It's a testament to the brave whistleblowers, the dogged journalists, and the honest officials within the system who refuse to stay silent in the face of such betrayal. The integrity of our justice system is not an abstract concept. It's the invisible thread that holds our society together. It ensures that there is one set of rules for everyone, whether you are rich or poor, powerful or powerless. When that thread is weakened by corruption, the entire fabric of our democracy is at risk. It affects every single one of us, because a compromised court could one day be the one deciding your fate or the fate of someone you love. It's a problem that belongs to all of us, and so does the solution. This is why we can't look away. Corruption in the justice system affects us all. Stay informed and demand accountability. Talk about these issues, support the organizations that fight for transparency, and celebrate the honest judges and magistrates who do their jobs with integrity every single day. The price of a functioning democracy is eternal vigilance. Let's make sure we're all paying attention, because the moment we stop watching is the moment the blindfold on Lady Justice slips for good. Thank you for watching.